Coelho, Secretary of State for the Home Department.
Good morning, Mr. Cooper. Oh, sorry. Miss Ailes. Forgive me.
My lady, before I introduce the rest of the representation, may I begin by apologising to the court and to the court clerks for the difficulties that there have been with the bundles. We're very sorry.
Well, that's very gracious. I'm sure it's not your fault. You will appreciate that it has caused us a certain degree of inconvenience. Can I, while you're on your feet, inquire whether Council have managed to, between them, work out a timetable for this hearing? Because it has to finish today.
Yes, absolutely. We have. It is subject to the question whether the court would be best assisted by hearing me open the appeal as a whole, or whether the court would be best assisted by hearing first the submissions on jurisdiction and then the remainder of the issues. If we took the latter course, we anticipate spending about an hour on that.
I think we know enough to hear it all at once. Thank you.
Well, thank you.
Please, have I correctly pronounced your surname?
Yes, Victoria Ailes with Miss Townsend for the Secretary of State, Mr. Cooper with Miss Foote and Miss Nice for the respondent.
Yes.
Mr. Hyman, who sits in the back row, for Portugal, and Mr. Evans and Mr. Williams, who sit behind me for
USA.
the United States of America. And my lady, just so that you know what to expect, I will deal with the issues in the appeal insofar as they relate to grounds 1 and 2, and Mr. Cooper will respond. Ms. Townsend will deal with ground 3, and I understand that Ms. Foote will respond. And I think there will be some submissions from at least Mr. Hyman also.
Well, we've had very helpful skeleton arguments from all of you, which we've read. We've read into the papers as much as we can.
Yes.
But you take your own course.
Thank you. My lady, for the purposes of the
My lady, my lords, there's just one point I thought it may be helpful to the court to raise at the outset, which is the core proposition on behalf of the respondent is that the court has no jurisdiction to hear this appeal,
yes,
as the court's aware. That would normally be dealt with as a preliminary issue, and there is plenty of authority to show that, for example, where the Privy Council is dealing with a jurisdictional point, it doesn't then go on to pronounce on the merits because it has no jurisdiction to do so. And so that would be the conventional and correct approach in my submission. And obviously it might have been helpful if there had been directions to that effect from the outset.
But it might have been helpful if they'd been sought. Yes,
but I simply raised that as because my lady addressed that already. I thought you may wish to hear from me briefly at the outset on that issue, because in my submission the jurisdictional issue is absolutely plain. This is the quintessential criminal causal matter. The extradition proceedings are criminal proceedings. The underlying domestic criminal process is live and pending, and therefore the court can't actually go on to pronounce on the other issue. So I thought it may be helpful.
If we're with you on that point, then maybe we won't need to deal with the other issues in the judgment. But in terms of the efficiency of use of court time, I would prefer to get on and hear the meat of the case.
Very well, thank you.
Thank you. My lady, I propose to adopt the course which I took in my skeleton argument of dealing with the meat of the case first and with jurisdiction second.
Yes.
My lady, this is obviously a case, my lords, about the analysis of section 179 of the Extradition Act 2003. And I will come later to the details of that provision.
Yes.
But I'd like to begin by setting out the wider purpose of the Extradition Act taking you to some of the materials in relation to that, and dealing with the extent to which we submit the appeal, the decision under challenge, runs counter to that statutory purpose. So the purpose, first of all, the main purpose of the Extradition Act was to streamline the system of extradition, to reduce delay, to eliminate complexity, and in particular to avoid the duplication of legal proceedings considering the same issue many times over. Because the procedures under the predecessor legislation, the Extradition Act 1989, and before that the Fugitive Offenders Act, did permit such repetitive legal challenges, which stalled the process going over and over the same ground repeatedly, and that therefore was what the 2003 Act was introduced to avoid.
Yes.
The main mechanism for doing that was to remove the Secretary of State as far as possible from the process in order to avoid situations in which that would happen. And that was done by removing the Secretary of State entirely under Part 1 relating to European Union member states, and as far as could well be managed under Part 2 dealing with the rest of the world. May I begin by taking you to tab 4 of the authorities bundle, which is the explanatory notes to the Extradition Act.
Yeah.
So I'm looking here at the first volume of the authorities bundle, which I will call the statutory materials bundle. And what I draw the court's attention to is paragraph 9, which explains that the Act is introduced following a consultation document, the Law on Extradition, a review in March 2001. It describes some of the contents of that document, but we're going to come straight to the document, so I'll skip over that. And then at paragraph 12, the Act makes provision to give effect to the proposals in the review, although there are changes which reflect the results of the consultation exercise. So that is the context in which I introduce the document behind the next tab, tab 5, which is the review in question which led to the Extradition Act.
Why is that admissible?
It goes to the mischief, my lady.
If we're construing a statute, we're entitled to look at the explanatory note, but why should we look at a consultation exercise which partly was implemented by the statute? I can't see why that is admissible on a point of construction.
Well, I appreciate that that would be the position if it were a consultation properly so described. My submission is that it is really more in the nature of a white paper, in the sense that it contains recommendations.
Yes, some of which were taken up and some of which were not.
Well, the passage that I have just read indicates that the Act makes provision to give effect to the proposals in the review.
Apart from the adjustments in response to the consultation. I mean, we don't know what adjustments were made in response to the consultation, so I don't at the moment see the utility of looking at this document.
Well, my lady...
Anyway, you show us which passages you want to show us, and then we'll make of it what we will.
Could I ask you please to go to page 400? And could I ask you to just read from paragraph 25, which is the last paragraph on that page, down to the end of paragraph 34, which is the end of the page following. Thank you, my lady. What is contained in that extract is, in my submission, a helpful summary that indicates, first of all, in a concise way, what changes were introduced if one were to go through the process of comparing the previous legislation with this legislation, which would be an arduous task at this stage, and a distillation of principles which were very well understood by the courts both before and after the changes. May I add that there were then further changes introduced into the Extradition Act following the review by Mr. Justice, Sir Scott Baker, which is at tab 6 of the bundles. Now, my lady, there are certainly authorities that say that this may be used as an aid to construction of the Act. They're not in the authorities bundle, but if it's helpful, I can supply them. May I won't invite the court to read it now, but may I, for your note, invite the court's attention to 919 on page 466
Yes.
through to the end of 930 on page 468. And what this passage explains is that there remained at that time some functions for the Secretary of State for the Home Department in relation to Part 2 of the Act, in particular in relation to consideration of human rights issues, which was done at the final stage before extradition took place. And the recommendation of the authors of this review was that that should be changed, that human rights should become solely at the purview of the courts, and in consequence of this review, amendments were introduced by means of the Antisocial Behaviour, Crime and Policing Act 2014, in particular to Section 70 of the Act, which now says that the Secretary of State cannot consider human rights at any time after a request has been certified under Part 2 of the Act. Obviously, the Secretary of State has no role at all anyway in relation to Part 1. So the reasoning behind that, which is of importance, is that the Secretary of State's involvement is here being limited to the matters with which she is best able to deal as a Minister of the Crown.
Yes.
Because she deals still with the death penalty, because that is dealt with by seeking assurances under the relevant treaties from the state concerned. She deals with issues relating to specialty, because it is to the government that a request would need to be made to proceed for something not covered by the original extradition request. And almost everything else except human rights is now excluded. So what we see from this is the development of a distinction between the Secretary of State exercising the diplomatic, treaty-facing function and the courts protecting the rights of the individual.
So the death penalty function that is retained by the Secretary of State is notwithstanding that would engage an argument under Article 2.
That's so in relation to a case in which it was assessed that that somebody would lose their right to their life.
Which is an absolute right, but it is also part of the Human Rights Act. So how does the retention of the death penalty proviso square with the provision that says that the Secretary of State can't consider human rights? It may not matter for this appeal, but I'm interested.
I'm pretty sure I know the answer, but may I turn my back?
Yes, of course.
We're not sure, but my understanding is that when we joined the convention, we ourselves still had the death penalty. Article 2 does not actually prevent the imposition of the death penalty in the execution of a sentence. There is a separate protocol which separately outlaws the death penalty. So I anticipate that there's, as it were, a loophole.
Right.
Which the Secretary of State, by seeking assurances, closes.
But
That's somewhat speculative.
in any event, the right to life in the decisions that are actually made by the Secretary of State is a given, and her responsibility is to ensure that the assurances that are given by the requesting state will in fact protect the life of the person being extradited. No right to life argument arises, that's accepted.
Quite so, and any question of Article 2 arising would be expressly precluded by Section 70, yes, 70 subsection 11. Moving on to a slightly different aspect of the framework, may I take you next to the special objective in extradition proceedings at tab 7, page 472. You are obviously aware from our skeleton argument that we rely on the special objective of the conduct of extradition proceedings in accordance with international obligations, including obligations to deal swiftly with extradition requests. So that's the second limb, the speed point. It may also, certainly in the context of some of the submissions that have been made by the requesting territories in this case, be relevant to note the importance of mutual confidence between judicial authorities.
Yeah. Well, I suppose that has a limited operation in a sphere where you've got two competing requests for extradition, because one of the states is going to be disappointed.
One of the states is going to be disappointed. My lady, my submission is that one of the states should be disappointed as quickly as possible.
Yes. But everybody needs to know where they stand as quickly as possible is the answer.
Absolutely.
So that
Yes.
the person of interest can be extradited swiftly, and that's the whole
Yes.
purpose.
And that's plainly in the wider interests of justice and the ordinary, let alone the special overriding objective. I have set out in paragraphs 15 and 16 of our skeleton argument, which is at page 373 of the core bundle, details of the international obligations which require requests to be fulfilled swiftly. Sorry, that was 373.
I've actually put it in a separate bundle. So. Paragraphs, sorry?
So paragraphs 15 and 16.
Yeah. Yes.
For the EU, it is as a matter of urgency and within 60 days, with, as you see there, the potential to extend by a further 30 days, but no discussion of the possibility of extending beyond that. And then, in the case of the United States of America, under the bilateral treaty, promptly. That's Article 13. May I unpack a little bit further what that means, particularly in Part 1 cases, because obviously the entire point of Section 179 is that you always have one case under Part 1 and one case under Part 2. So on any view, the Part 1 case will be affected. And I'm just going to run through some of the deadlines in the Act. I have, I'm afraid, taken the decision to give you the whole of Parts 1 and 2 of the Extradition Act, and I know that that's a lot, but it is very much a scheme that has to be viewed as a whole. I'm not going to go to the individual sections now, but I'll give them to you. So, in a Part 1 case, the early provisions deal with arrest. Section 8 provides that the substantive hearing has to begin within 21 days of arrest. So that's the substantive hearing in the Magistrates' Court. Having got judgment from the Magistrates' Court, you have to give notice of any application for leave to appeal to the High Court within another 21 days. That's Section 26.
Sorry, how many days?
21 from judgment.
Yes.
The criminal procedure rules, we don't actually have this in the bundle, but it's 50.23, say that unless the High Court directs otherwise, the hearing of the appeal to the High Court must begin no more than 40 days after the defendant's arrest. So that's arrest, not the date of the magistrate's court hearing.
That could be problematic to achieve, couldn't it?
It's mathematically challenging. It's practically
Impossible.
unachieved. Yes. But my submission is that however much this is honoured in the breach, and it very definitely is, this is a scheme that has been designed to attempt to comply with our treaty obligations.
Yes.
And the fact that we may fail to do that does not affect the enormous importance that this Act is clearly trying to place on speed.
Yeah.
Let me conclude that by saying you have 14 days to apply for leave to appeal to the Supreme Court under Section 32, and then another 14 days to apply to the Supreme Court itself if that's unsuccessful. Theoretically, that would take you to a refusal of permission if it was refused in the Supreme Court in 68 days by my calculation, which is itself already a breach of our obligations under the Trade and Cooperation Agreement. So that's essentially what I want to say on the mischief that the Act is intended to address, to minimise delay, to avoid a multiplicity of legal challenges with everything going through one appeal process, to minimise the role of the Secretary of State even in Part 2 cases, and to achieve a position where the Secretary of State's function is to deal with the United Kingdom's treaty obligations, whereas the Court's role is to deal with the interests of the requested person.
Yeah.
May I turn next to the practical ramifications of the judgment that's now under appeal? Because we submit that the consequence of that judgment is to create or confirm, depending on your perspective on it, the very mischief which the entire legislative scheme is intended to prevent.
This is the first point of the judgment because this is the reading in of the right to make representations. You say causes extra inbuilt delay, which is contrary to the intention of Parliament.
Yes, my lady. I should perhaps have said already, I'm really making my submissions on grounds 1 and 2
Yes.
together.
Yes.
We
I mean,
feel
if the
compelled.
Secretary of State made a decision on a wrong factual basis, she made it on a wrong factual basis.
Absolutely, and that is an issue that can be very clearly separated, which is why Ms Townsend's
Yes.
dealing with it.
Yes.
And without prejudice to the merits or otherwise of her submissions, of course we accept that if the Secretary of State did make a decision on a basis that's amenable to public law challenge
Yeah.
on the facts, then
I mean, that will cause some delay, but
It will.
it's part and parcel of the fact that it's a decision made by a public authority
Yes.
in exercising a public function. So that aspect of the judgment isn't really what's the matter of gravest concern. The concern is this building in of a right to make representations before the decision is taken.
yes, my lady, for two reasons. Firstly, because we submit, and that's what I'm about to come on to, that the involvement of those interests will add very substantially to the delay that's involved in taking the decision, and also because on our narrow interpretation of what is permissible to take into account, and on the extent to which the Secretary of State is really dealing with relations with foreign partners, the threshold for review would be that much higher, and it'd be that much less likely that challenges would run or would get permission. I don't, of course, say that that's determinative, but it is the reason for the concern.
Yes.
So the essential answer, and yes, to be clear, we put the interests point first in our submissions because it is frankly difficult to see how, if the personal and private interests of the individual requested person are relevant, any decision could fairly be taken without finding out from him what they are. So it seems to us that the question of interests is logically prior to the question of representations. The answer that was given to the appellant by Mr. Justice Linden was essentially, you can set tight deadlines. And he made, in fact, although it was stayed, an order for representations to be made within 28 days. Well, the point that we make about that is that that's the position in circumstances where there had already been extradition proceedings in the magistrates' court. The respondent was provisionally arrested on the 22nd of January 2022. We have a judgment from District Judge Sternberg dated 7th of June 2023, which runs to 127 pages, 155 paragraphs, and sets out in a great deal of detail information about the respondent's mental health, his autism diagnosis, his suicide risk, the fact that he's a victim of modern slavery, and his connections with his friends and family. And the point about that is a coincidence of the particular chronology that has occurred in this case.
And all that information would have been before the Secretary of State?
No, none of it.
That's the point.
Yes. And I fully accept that if I'm wrong about interests, then we start to get into the question of how much of it should have been. My submission is it shouldn't have been. It's plainly duplicative.
But is it your submission that none of it is relevant to the question of choosing which of the two countries should prevail in terms of the extradition warrant?
Yes. And there is more that I could say, my lady, about the volume of material that this court now has.
Yes.
And is being invited to consider as potentially relevant to the requested person's interests. But perhaps I will skip straight to the legislation at this point.
Yes.
Could we go, please, to the supplementary bundle at page 156?
Is this a government publication of some kind?
So this is the Secretary of State's guidance, and rather than going separately to the statutory materials, you will see that immediately following it at page 158 is an annex to it which contains the legislation. So just for convenience, I'll use that version.
Yes.
So Starting with the legislation then, on page 158, obviously we know that we're dealing with situations in which we've got a Part 1
And a Part
warrant
2.
and Part 2 request. The matters to be taken into account, mandatory matters, are at subsection 3, and there are 4 of them. If we move to the preceding page, we see that the guidance, having set out those 4 mandatory matters, says at paragraph 7 that there are matters which may be taken into account, and it lists a further 7.
So that's a permissible but not exclusive.
Yes. So it wasn't necessarily framed in this way in the court below, but in our submission, the essence of what Mr. Justice Linden has decided is that either this guidance is unlawful insofar as it fails expressly to say that the interests of the requested person must be taken into account, or at least that it's unlawful if it's not treated as if that is a mandatory consideration, which you may think is a distinction without a difference. So it's effectively that the Secretary of State's policy is unlawful when viewed in the context of the Act. Our central submission on the mandatory and the permissive factors is that what they all have in common is that they are about securing the wider interests of justice in seeing those against whom there are allegations brought before a court and those who have had sentences imposed on them serving them. And doing so in the way which best reflects the interest in making sure that offenders face justice globally in both the literal and metaphorical sense, and also practically. So, as seems relatively obvious, the seriousness of the offences is listed. Under the policy at 6.1, it actually says this will usually determine which of the claims takes precedence. Obviously, it's not so determinative in this case because of the, at the very least, substantial overlap between what was alleged. But
The dates as well. I mean, it would have been open, presumably, to the Secretary of State to have had a first come, first served policy, but she's decided not to do that.
she's decided not to be so wholly prescriptive
Yeah.
as that. Query whether she could have been, because of course consideration of all 4 of these factors is mandatory.
And you could have an earlier request for a fairly trivial matter and a subsequent request for murder.
Yes. But what you may think is that this is balancing questions which ought to be apparent on the face of the request or the warrant. May I note that there's a reference to nationality under the location heading at 6.2. Our submission about that is that that does actually fit with what I'm describing, because one can view it as the interest that requesting states have in what goes on in particular in relation to their own nationals, in both the sort of consular sense and in the wider diplomatic sense. It's a factor which may be relevant to, in this case, America and Portugal's interests. We submit it's not a factor that may be relevant to respondents' interests.
Yes, I see that. So you say that if the requesting state is a state and the person who is being requested is a national of that state, then they're saying, well, notwithstanding that they may be in your country, we have the right to have them tried in our country for whatever they've done, just in the same way as the UK would say that a murder is a murder even if it's committed in Venezuela.
Yes, I wouldn't put it as high as the right, but the Secretary of State is certainly entitled to say, well,
we have an interest.
Clearly,
a legitimate interest.
There's a legitimate
Having
interest
tried
in trying your own nationals, and of course, not all countries permit the extradition of their own nationals if they're arrested in their country of nationality. So that's the central submission on this, that in terms of construing the four mandatory factors in the legislation, they're essentially factors of the same type.
Yes.
But this list is extending them, and that, to use the old Latin phrase, the eustem generis principle would not permit the insertion of the interests of the requested person, which are of a wholly different nature.
But, I mean, one wouldn't apply that principle when construing matters of policy.
No, I'm talking about the...
But I take
Act.
your point. You say that these are all dealing with a particular genus of factor.
Yes.
And looking at the human rights or other personal interests of the extradited person doesn't fit within this scheme at all.
Exactly. Yes. Can I develop that a little bit by also taking you to the factors in the two international agreements?
Yes.
So, page 13 of the statutory materials, we have the US-UK extradition treaty.
Where do you find those? Are they a separate bundle?
It's the first bundle of the authorities. The statutory materials is bundle 1 and the cases is bundle 2.
The big bundle. Yeah.
It's the one we were looking at the beginning of March.
Tab?
Tab 1.
Yes.
So it's page 13, article 15. What we see there is a list of very, very similar factors indeed. The only one which is extraneous is whether the requests were made pursuant to a treaty. Obviously, in this case, they were in both cases anyway. The reason for going to this is that the point is made against me that the final sentence before the subcategories, in making its decision, the requested state shall consider all relevant factors.
You say that begs the question of what's meant by relevant.
Yes, and it takes us exactly back to what is the genus of matter that the Secretary of State considers.
Yes.
Likewise, the Trade and Cooperation Agreement, the provision there is at page 50, tab 2. They're less helpfully not subdivided in this case, but it's within the text of 6141. So Again, the point will be made against me with due consideration of all the circumstances. I give the same reply. Relative seriousness of offences, place, respective dates. So far, so good. Whether they've been issued for the purposes of prosecution or for execution of a custodial sentence or detention order. And legal obligations of member states deriving from union law regarding in particular the principles of freedom of movement and non-discrimination on the grounds of nationality. Now, what I say about that is that one has to look very carefully at the words member state, because under the Trade and Cooperation Agreement, a member state is an EU member state, and where one is dealing with all of the parties to the agreement, the word state is used on its own, uncapitalised, and it's not in the bundle, but if you want to look it up, you'll see that in Article 6. So, in effect, what that is saying is that, and it's important to recognise the structure of this. Paragraph 1 is dealing with competing European arrest warrants.
Yeah.
So that's when there's two Part 1 cases. The list remains relevant, but it's relevant because it's incorporated by reference in paragraph 3. So in the event of a conflict between an arrest warrant and a request for extradition presented by a third country, the decision is taken by the competent authority of the executing state. Sorry, it is capitalised, but that's obviously UK or EU, with due consideration of all the circumstances, in particular those referred to in paragraph 1. But that, I submit, means that we at least are not considering EU law. And it's also relevant to note that the structure of this provision recognises that where it's a conflict between a Part 1 and Part 2 case, the decision is made by a competent authority, whereas within the European Union, because it is an area of freedom, security and justice, and is an entirely judicialised process, the decision is made by a judicial authority. So that's why competent authority appears in 3 compared to executing judicial authority in the third line of 1. And I will develop that when we come on to the OP case.
I was wondering why this treaty is concerned at all with the position as between 2 member states, when the whole objective is to facilitate the extradition system between member states on the one hand and the UK on the other.
So if one envisages a situation in which the United Kingdom, for example, got requests from both France and Spain,
Yes.
that would be dealt with under a separate provision under Part 1, not under Section 179,
Yes.
and that would fall within subparagraph 1. If France, for example, got a request from the United Kingdom, but also one from Rwanda, this is recognising that France would not make the decision via its judicial authority because you need to reflect France's wider treaty rights, but it is saying we nevertheless, as the European Union, expect these matters to be considered in order to give appropriate prioritisation to European requests.
So you say, notwithstanding the width of the expression all the circumstances, it means all the relevant circumstances, all the relevant factors, and that narrows it down.
Yes, I do. Insofar as it's clear that the list in 179 is intended to reflect what is in these two treaties, I have given you at tab 12, we don't need to go to it, but the authority of Postlethwaite, which makes the point that the court should not, unless constrained by the language used, interpret any extradition treaty in a way which would hinder the working and narrow the operation of the most salutary international arrangements, it says. So that is at 947F within the internal pagination in the report. May I deal with the case of OP, which is at tab 19 at page 310. And the reason for dealing with it is essentially that the court below treated this as an authority in favour of the conclusion that it reached, and my submission is that in fact on analysis it's rather the opposite. So the position here was that OP was a French national, was arrested in Spain, was wanted on a European arrest warrant by France, and was separately requested outside of the EAW scheme by Switzerland. And that meant that it's obviously not Article 6143 because the United Kingdom wasn't involved, and I think it was probably prior to the TCA entirely, but the corresponding provisions under the framework decision that used to apply to us as well was invoked. Could I pick up first of all with the question that the court addressed at paragraph 29? It is looking there at the question whether the competent authority, which you'll recall is the authority that makes the decision under 6143, is maybe an executive body. And in short, the answer to that is yes. So we see that at 37 at the beginning of the sidelined passage. And going to the following page, we see some discussion of the legal impact of the decision on the requested person. So picking up at paragraph 52, as the Advocate General observed at point 91 of his opinion, and for what it's worth, that's behind the next tab in the bundle, that decision on precedence is liable to have a significant impact on the legal situation of the person concerned. And you can see there, I'm sure, the point that's going to be made by the respondent. Well, hang on, if it's having a significant impact on the legal interests of the person concerned, why does that not say that those factors are relevant? Well, the answer to that is in the second sentence. If precedence was given to the extradition request, that means the request from outside the EU, and no remedy could be sought against the decision on precedents, the effect would be that any restriction of infringement of the fundamental rights and freedoms of the person concerned enshrined by the Charter could be ignored, because in the vast majority of situations, extradition procedures are not a matter of EU law. So in our submission, what the court is dealing with here is, it is saying, we, the Court of Justice of the European Union, are here to deal with issues of EU law. In particular, we have to ensure that charter rights of EU citizens are protected. And therefore, we need to make sure that if a body which is not an EU body, an executive body in Spain, makes a decision to send someone off to Switzerland, which may be a decision under a treaty which is entirely out with the European Union's control, we need to formally ensure that charter rights, which for these purposes are the equivalent to human rights, are going to be protected. So, at paragraph 55, in the event of a conflict, a body of the executive may take a decision granting precedence to one of those instruments. There must be an effective judicial remedy against that decision, subject to the procedural conditions that it is for member states to determine. We submit that what that is saying is that the individual EU member state must ensure that the EU national is able to raise their charter rights, because that's the scope of what the court is entitled to decide. It only decides matters of EU law, it doesn't decide matters of domestic law.
Well, what it seems to be suggesting is that they should be entitled to raise their charter rights as a ground for challenging the decision, which is a decision as to which of the two extradition requests should prevail. On its face, anyway. That's what it seems to suggest.
Speaking plainly, my lady, one does have to recall when reading this that in most EU member states they just send people off. The judicial aspects of the process can be very brief indeed, and many EU member states do achieve, just send people off is perhaps an unduly flippant way of looking at it, but there is not the excessive
why the court
judicialisation.
said there must be an effective judicial remedy.
Yes, well, our submission on that is that the effective judicial remedy is the extradition proceedings in which, at least in this country, the judicial remedy is the extradition proceedings that have been brought with the United States of America as the requesting state, in which the issues of human rights have all been looked at, because the remedy
that's
is...
a very interesting way of looking at it, Miss Ailes, but the trouble is that the whole of this passage is dealing with the decision on precedents, and that's the subject of the whole discussion. And so what we got, rightly or wrongly, is the Court of Justice saying there's got to be an effective judicial remedy in relation to the decision on precedent. Now, you might well say, well, you've got judicial review, and that's an effective judicial remedy, and so you don't need to worry about anything else. But then you've also got to look back at what's said in paragraph 52, which seems to suggest, on the face of it, that an infringement of human rights does come into the question of which of the two countries should take priority.
Well, my lady has articulated the case against me admirably, if I may say so. May I have one more go?
Yes. Well, I'm just trying to get my head around the answer to the point, because you said that the answer lay in the second sentence of paragraph 52, and I read the second sentence of paragraph 52, and it seemed to say the opposite of what you were submitting. So I obviously haven't followed the argument, and I just want to give you another chance to explain.
What it says that I'm focusing on at the end of 52 is extradition procedures are not a matter of EU law.
Yes.
So it is because the process for extradition to Switzerland is not a matter of EU law that the court is saying we need to make sure that in this situation there is still protection for charter rights.
Yes.
At the end of paragraph 55, it makes clear that it is subject to the procedural conditions that it is for the member states to determine. So the EU has nothing to do with the form of the remedy. What the EU is fundamentally concerned about is that OP is not sent to Switzerland without examination of whether that is precluded by his charter rights. And our submission is that if you have extradition procedures which involve an examination of charter rights, that is the remedy.
So if you've got a case where under the French system of extradition there isn't that consideration before he goes to Switzerland, then at the time that you are dealing with the extradition request and balancing that against another request, it's got to be brought in. But you say if it's all, provided it's brought in somewhere in the procedure, it doesn't matter at what stage.
Yes.
Is that really the point?
That is really
I
the
understand
point.
the point. Yeah.
And so it goes back to the UK approach of avoid duplication and parallel proceedings.
Right.
I should perhaps make the other points about this, although they're far more obvious. You are not bound by the Court of Justice of the European Union. But also the point that I've already made about 614 only relating charter rights to EU member states and not to us under the TCA. And equivalently, you may think it would clearly be one way or another a violation of somebody's human rights if they were to be extradited to the United States without any judicial examination of their human rights, whether that arose as a declaration of incompatibility under legislation or simply a failure to follow procedures. But it would not be a violation of anybody's human rights simply for the matter not to be considered at the priority decision taking stage.
Well, the safety net, you say, lies in the fact that it's baked into the extradition process.
Yes.
The streamlined extradition process says we will consider somebody's human rights at that stage. If the extradition request is a lawful request, they've already been considered and you don't need to do it twice. I suspect it may well be said against you, well, that's all well and good if you look at the two extradition requests independently, but when one's carrying out a balancing exercise as to which one of them should take priority over the other, it's at least theoretically possible that they might come into play again.
Yes, well, this comes back to whether interests are relevant at that.
Yes.
At this stage. So all I have to establish is that it is lawful to say, my starting point is there's no question of anybody being extradited in violation of their human rights.
Yes.
And therefore, I don't need to do a separate
Don't need to
balancing
look at it
exercise.
again.
Yes. Now,
Is it that when choosing priority between two different extradition requests, the Secretary of State is actually dealing with, or presuming she's dealing with, two requests which will survive or have survived challenge on human rights grounds elsewhere and are therefore lawful?
yes,
So she could lawfully grant either of them, and
yes,
she has to choose which to grant.
yes. That's pretty much what it amounts to. And if one were to sort of transpose this into the ordinary criminal context rather than the extradition context. I mean, it's a bit difficult to do because there's a sort of practical difference, but it's very difficult to imagine anybody trying to judicially review the police because they decided to arrest somebody for one thing rather than another thing, or because they hadn't taken into account whether they might prefer to be tried first in Aberystwyth or in Scarborough.
The latter one I've not come across, the former I have.
My lady,
You'd be amazed what the subjects are for judicial review in the administrative court, but...
All right, well, I'll settle for it's amazing that this judicial review was even brought. That does bring me on then to how exactly we deal with fairness in this situation. Because essentially what is said against me is, well, the Secretary of State can't consider human rights. That's accepted. Section 70(11), absolute barrier. But she may consider whether it would be somehow more proportionate to send somebody to one place rather than another. And our answer to that is essentially the one that the court has already articulated. In other words, once you have established that it would be lawful for both requests, for either request to be executed, that's all you need to determine. And if the proceedings haven't concluded, then you're entitled to work on the basis that if there's any concern, the proceedings will deal with it. Now, we fully accept that that may mean that there are cases in which people are extradited to countries which they would prefer not to be extradited to. But they will be extradited to countries that there is no legal bar to their extradition to, and we say that's not objectionable. The analysis in relation to representations obviously hangs very significantly on whether the interests of the accused are relevant. It also
sorry to keep asking you questions, but could they be relevant in a narrower sense? Let's assume you're right for present purposes. It does occur that if representations had been made on behalf of the respondent to the Secretary of State, the alleged mistake, or the mistake that the judge below found, might not have been made, because at least it would have been open to his legal representatives to say to the Secretary of State, well, there is a massive difference between what I'm facing in the US and what I'm facing in Portugal, because in Portugal there's the tax and there's also the money laundering. And because of all of that, when you're looking at the seriousness, etc., you've got to take all of that into consideration.
One can conceive of a situation in which such representations were made. To some extent one can see it, because in the very long judgment of District Judge Sternberg, he does consider evidence from the requested person, oral evidence, about matters relevant to forum. And we see that some of that evidence is contested or contestable.
But none of that is going to be before the Secretary of State. See, the Secretary of State is taking this decision in a complete vacuum, you've told me. Doesn't see what the district judge said. All that she's concerned with, on your analysis, assuming it's right, is other factors that are listed in the guidance, and that will include the seriousness. But it might be said, well, the advantage of baking in representations as a matter of fairness is that that's the only opportunity, short of a judicial review, which is likely to add to the delay, which is inimical to the process, a very brief opportunity for a very short period of time to make representations on limited matters that are relevant might actually avoid mistakes being made.
One can always make that point, and one can always add additional safeguards and additional processes to try to stop mistakes being made.
The question is whether that is a matter of procedural fairness.
And what we submit is that comes back to the part of the special objective in extradition proceedings which deals with mutual trust and confidence.
Yeah.
So the ordinary presumption is that you accept at face value, unless there is a reason to go behind it, what it is that your trusted extradition partners are telling you. And that for the Secretary of State to involve herself in a process of adjudicating between what the requested person says, the factual position might be in relation to what is alleged, and what the requesting state says, is thoroughly undesirable. Also because it undermines that trust and confidence, as well as because of the factual and practical ramifications. May I, just so that we see some authority on representations in the extradition law context, take you to Ex parte Norgren, which is at tab 14, page 85 of the authorities bundle. Sorry, I've taken you straight to the part that I want to go to. We're in the year 2000, so we are prior to the 2003 Act.
Yeah.
We're dealing here with a process under which the Secretary of State has a decision-making function at the beginning.
Yeah. And at the end.
And at the end. We're dealing with the Secretary of State's function at the beginning, which it's fair to say was usually the less contested part of the process. The applicant essentially made representations about that initial decision. They were then, for reasons that don't very much matter, put into abeyance, but representations were made saying, can we make more representations if the question of an initial decision becomes live again? The Home Secretary ignored and did not acknowledge the request for an opportunity to make additional submissions. And so what we see here is Lord Bingham's approach to the fairness of the Secretary of State then having gone on to make the initial decision without seeking those further representations. So the second sideline paragraph at H, the statutory scheme makes no provision for representations to be made by the object of an extradition request before an order to proceed is issued. The case of Macquarie highlights the general undesirability of prolonged representations and counter-representations at this stage. There was, so far as we know, no contact between the Home Secretary and the applicant or his solicitors before the provisional warrant was issued and executed, and such contact would not be normal. I'm moving down to about 60% of the way through. It's not standard practice in an ordinary domestic context to warn a person of his impending arrest. Where the extradition of the party in question is sought on the grounds that he is a fugitive criminal, there are obvious practical reasons for not giving such notice. The Home Secretary never led the applicant or his solicitors to think an opportunity would be granted. They were entitled to hope, but not to expect. In our view, the Home Secretary was not guilty of procedural unfairness in acting as she did. I appreciate that it's at the arrest stage and therefore only takes me so far, but I do rely on that as demonstrating what procedural fairness requires in an extradition context, and I do submit that that can be transposed into the priority decision, which likewise we submit is about an instituting or continuing stage of the process.
Can it really be transposed on the basis that what they were arguing about was the opportunity to make further representations, not initial representations?
Well, Lord Bingham makes the point that it's not normal to make
Get somebody
representations at all, to have contact.
Mm.
So in my submission, he's not saying that there's an obligation. And of course, and it's one of the potential issues with the current situation, circumstances may change. The reason why renewed representations are made is that it's said that circumstances have changed, mental health has got worse, prison conditions have altered, whatever the argument is. But of course, every time that there's a material change and fresh representations, that has the potential to start an entire new procedure. And if the judgment below stands, we don't regard it as entirely absurd to suggest that there may well be renewed representations under Section 179, even after a decision has been made, and while appeals are still ongoing in the substantive proceedings.
You say that the place to actually make representations about changes of circumstances would be by way of appeal in the substantive proceedings.
Yes. And there are
What if
provisions
they come to an end and you've exhausted your rights of appeal? What then?
There are provisions that enable you to make an appeal on human rights ground at any time up to extradition under Part 2.
Right.
And that again was a recommendation of the Scott Baker review, because previously it was the Secretary of State's function. I'm just going to take a moment, my lady, to go through my note and see what, if anything, I have missed. Yes, may I deal with the point about other time limits for representations in the Act? You'll have seen this dealt with in Mr. Justice Linden's judgment. If we go to page 274 of the statute bundle, the first authorities bundle, we have there section 93 of the Act. So this is the provision
Not in my bundle.
274 in part 1 of the authorities.
Oh, hang on, I've got two lots of 294. Yeah, make it 274.
274.
The first page 274, yes.
It's section 93
Yeah.
in the Act, if that's an easier way to find it.
Just put it down. Tab 3.
Yes, tab 3. Yeah, most of that bundle is tab 3, but so we see there the few decisions that the Secretary of State does retain.
Yes.
What I want to look at is subsections 5 and 6. So the Secretary of State may receive representations on those issues, but is not required to consider any representations received by him after the end of the permitted period, and the permitted period is essentially 4 weeks. Now, the point that Ms. Cumberland made below and that I repeat is that this is a piece of legislation which is astonishingly prescriptive. I won't take you through it now, but when you're considering your judgment, can I invite you to just read the Act starting from around section 11 or so, and just see the way that it follows through, because you have a whole series of sections which say, you know, if the answer to question 1 is A, go to section 19. If the answer to question 1 is B, go to section 21A, etc., etc. It's a flowchart in legislative form. It is far more prescriptive as to procedure than some pieces of legislation. And therefore the point that I make is that having omitted any reference to representations is, in our submission, a very clear indication that no submissions were expected.
Well, you pray that in aid, in addition to everything that you already said about the scheme.
Yes.
And the way it's supposed to work. So you say Parliament's purpose is to get this done fast, reserved only very limited powers to the Home Secretary. Everything else is dealt with within the confines of the extradition process. So at this stage, when you've got this conflict between the two and there's a choice to be made, then the fact that there is no reference to representations has to be taken as Parliament excluding the right to make them.
That's exactly right, yes. It's adding a layer of statutory construction onto what I've already said.
So you say that's enough to negate the Bank Malat approach?
I do, and I say that the bars to extradition are what Parliament intended to be the mechanism by which procedural fairness was secured, because if one looks at all of the procedural fairness cases that we've got in the bundle, I don't propose to go through them all, but what one repeatedly sees is that a decision is being made which is in some sense final. You know, a decision is being made as to sanctions in relation to Iran or in relation to planning or whatever it is. So the only redress is to make representations before that decision is made. What I submit here in this much more criminal context is that Parliament has said, right, what are the bases on which you should be entitled to resist this? We'll set that out as the bars to extradition. And therefore, because you've got that avenue, viewed in its statutory context, procedural fairness does not require anything more, and in particular it's not to be read in as implied.
Why is the decision not a final one if the Secretary of State has to choose between which of the two countries asking for this person to be extradited should prevail? It is final in that sense, subject only to judicial review, isn't it?
I mean, it's not final in the sense that if, in the case of Mr. Coelho, the request by the United States of America fails, then the next thing that happens is that Portuguese request is proceeded with. So
yes, I follow that. And you also, of course, remind us that human rights considerations can be brought into play right up to the date of the actual execution of the extradition warrant.
Yes. Yes. And so fairness, we submit, is secured by...
So it's not the last
authorities.
chance saloon, to use the vernacular. No.
No. And of course, human rights can't be secured by the Secretary of State because
No.
he's barred from considering.
Yeah.
Yes. Unless the court has any questions on that, I'll turn to jurisdiction.
Could I just ask you, we looked at the decision of the European Court of Justice and you told us it wasn't binding on us. What is its status?
It's binding on EU member states.
Yes.
There is obviously provision in the Trade and Cooperation Agreement that says that the United Kingdom is not subject to the decisions of the Court of Justice of the European Union. If my lord wants more on that, may I reflect over the luncheon adjournment?
Yes, I think, speaking just for myself, I would, because it's quite an interesting decision in this context, and it would be helpful to know what the right approach is to it.
Well, unless anybody will be put in difficulties by this, I'll deal with it in my reply if I can.
Well, that would be very helpful. I mean, I think that the general approach is that decisions of the CJEU, insofar as they are relevant on matters of European law at least, would be paid a certain amount of respect by this court.
Yes.
Even if they're not binding.
Well, a decision of the Supreme Court of the United States would be paid, I'm sure, a great deal of respect. Yes, it may be that my submission is that it's no more than that, but I will reflect.
So you're coming on to jurisdiction.
Yes, please.
The short point is this is a matter of statutory construction. That's that.
Yes, well, my lady now sees why I framed it as a challenge to a policy decision. Yes, my invitation to the court is to approach this on the basis that you don't need to look at anything that is in the authorities bundle prior to McGuinness. That McGuinness effected a really substantial change. It is gently expressed and framed as a reinterpretation of Amand, but it is a significant change of direction. This is a case in which a decision has been made by a member of the executive. If my learned friend is right, that means that we wouldn't be here, and therefore subject to certification and leave being granted by the Supreme Court, we would be left with a single tier of judicial consideration. May I draw 4 themes out of the McGuinness decision? The first.
Do you want us to go to it?
I know that my lady's very familiar with it because I have seen her name on one of the other authorities. If it would assist the court, I certainly can. I'm aware it's quite a substantial decision.
Very briefly, I think it might help to at least have it to hand.
All right. Well, it is at. I have skipped ahead. I'm sorry.
Tab 29.
Thank you very much. It is at tab 29 at page 470. The first point I'm going to make, I wasn't going to take you to the relevant passage anyway. That point for your note is page 500, paragraph 87. it's the point that you don't deal with this as a matter of impression. You don't deal with it on the basis that it's got a faintly criminal flavour.
Sorry, whereabouts are you?
I'm sorry, I'm at page 500.
Thank you.
So, paragraph 87. The context for that observation is that the court was overturning the previous decision in the case of McAtee, which is in the bundle, so treat that with appropriate caution. Yeah. Although the court does endorse some concern that was expressed in McAtee about how narrowly the civil jurisdiction had been construed.
Yeah.
The second point that I want to make relates to the use of the word directly. So perhaps it's best to start with the test. This is articulated in McGuinness, I'm sorry. That is at paragraph 77 at page 497. Lord Sales is dealing with the very old, but at that stage still leading case of Amand in the House of Lords. There had been a certain amount of previous judicial debate as to precisely the extent to which you should follow the subtly different formulations of Viscount Simon, Lord Wright, and well, it's just the two of them that are dealt with in this paragraph. I think Lord Wright generally regarded as the as it is imposing the slightly stricter test. Lord Sales resolved that debate by saying you have to satisfy both of them, which in itself might be said narrows the test. He explains what appeared in the earlier authorities, a phrase saying that you should give the widest possible interpretation to the phrase criminal causal matter, and he does that at paragraph 70 by saying the explanation for the earlier cases is that once upon a time in extradition proceedings, appeals were brought by way of an application for habeas corpus, or at least, if not appeals, appeals in substance. And therefore, what the cases were previously talking about when they said you give the widest possible interpretation to criminal causal matter was they were addressing the point that was being made by counsel, well, hang on a minute, this is a civil claim because it's a claim for habeas corpus. And they were saying, no. You don't look at the nature of the procedure, you look at the substance of the matter that's involved. And extradition was a criminal causal matter, and therefore an application of the habeas corpus, in effect an appeal in the context of extradition, was also. I should perhaps make clear we don't seek to dispute, because Lord Sales doesn't go that far, that extradition proceedings themselves would be a criminal cause or matter. What we say is that this is at one further step of remove, and what's really crucial here is the nature of the decision maker, the function of the decision maker, and may I say, I am somewhat fortified in my submission if I'm right in my submissions on the substantive appeal, although I certainly don't resile from them, even if the court finds against me on the merits. But it's it's the role of the decision maker, the nature of the decision being essentially an administrative and executive decision.
Well, that decision does not in itself result in somebody being tried for a criminal offence.
No.
The decision that results in somebody being tried for a criminal offence is the extradition decision.
Yes. And that's why the word directly in McGuinness is so important. And it's one of the words that was contested in some of the earlier case law. We have Von Lumi in the bundle, in which it was suggested that you could have cases where it wasn't direct and it was still potentially a criminal causal matter. Lord Sales is very clear. He keeps repeating the word. It's at paragraph 45, it's at paragraph 48, it's at paragraph 49. They must lead directly to exposure for criminal punishment. The other part of the judgment I rely on, again very briefly, for my Lord's assistance, is at page 501, where Lord Sales endorses McAtee, in which the court said it is in our view salutary that there should not be an over-expansive interpretation of the phrase criminal causal matter, and neither should there be an over-expansive approach to addressing the jurisdictional issue. To the extent that this is an open issue in this case, in that there's never been a decision on jurisdiction in relation to section 179, we submit that the categories should not be expanded further. In terms of the case law applying McGuinness, we submit that the most helpful case in terms of its similarity to the facts and in other respects is the case of Cleland at tab 35, which it's not entirely clear from the report, but I anticipate was following the Quinn decision in Northern Ireland at tab 30. So that was a case...
Cleland is which tab, sorry?
I'm sorry, Cleland is tab 35.
35, thank you.
Yeah. So it's a sideline passage at 582.
I ought to remember this, yes.
Yes. It was a case involving a decision by the Criminal Cases Review Commission, somewhat similar to the present situation in that it is at that stage at which a decision is essentially being made as to whether and what proceedings will occur, importantly by a body that was not then going to be a party to any appeal proceedings that then ensued. And my lady, it certainly appears from the judgment that that constitution of the Court of Appeal had no real difficulty coming to the conclusion that that was not a criminal causal matter, notwithstanding that that involved relying on McGuinness to overturn previous authority to the contrary.
Admittedly, it was we did decide that on a concession by counsel.
You did, my lady. It's a fact that quite a lot of these cases were decided on a concession by counsel, and that may be a point in my favour as well as against me.
Yes. Yes, particularly since it was common cause in the lower court that it was a criminal causal matter, and it was only when it got before us in the Court of Appeal that it was conceded that it wasn't.
It must be relatively unusual. We think that it is conceded that previous authority that's directly on point and that hasn't been expressly overturned must nevertheless be wrong.
Yeah.
That, unless the court has any questions, is jurisdiction. May I then hand over to Miss Townsend?
Yes, indeed.
I anticipate that we'll still be finished before lunchtime.
Miss Townsend.
My Lady, my Lords, I will address you on behalf of the applicant, the Secretary of State, in respect of ground 3, which is that the judge erred in concluding on the facts that the decision of the Secretary of State proceeded on a factually incorrect premise and failed to take into account relevant considerations and took into account irrelevant considerations. It's respectfully submitted that Mr Justice Linden made material errors in 3 essential respects. The first was when analysing the Secretary of State's consideration of the relative seriousness of the offending of the respective warrant and request, which is pursuant to section 179(3)(a) of the Extradition Act 2003. Second, when analysing the Secretary of State's consideration of the place where the offence were committed, pursuant to section 179(3)(b. And third, that these issues need to be considered alongside the judge's wider approach to the facts, and that the judge failed to consider the factor listed in section 179(3)(c), which is namely the respective dates on which the claim was made and how far it had progressed. If I may then turn to the first aspect, which is the relative seriousness of the offending. My friend Miss Ailes hasn't taken you to the actual text of 179, and I think it may be helpful to do so now. If you can look please at the statute itself in the authorities bundle, part 1, tab 3, page 380. We can see there the type of order that the Secretary of State may make under subsection 2, depending on which stage each proceedings are at. And then under 3, these are the considerations which the Secretary of State must take into account when considering these matters. A is the relative seriousness of the offences concerned. B is the place where each offence was committed or alleged to have been committed. C is the date when the warrant was issued and the date when the request was received. And D, whether in the case of each offence, the person is accused of its commission but is not alleged to have been convicted or is alleged to be unlawful at large after conviction. The final one, D, is not in contention. They're both accusation warrants. If I can then ask my Lady and my Lords to turn to the policy on which this decision was made of the Secretary of State. It's under Annex B, competing requests, which is in the supplemental bundle, tab 1C, page 11. And for convenience, I'll deal with all 3 of the considerations at once, so we can just keep flipping back. We can see there at paragraph 2, Roman numerals 1 to 3, that the essential considerations must be, according to this policy, are that the relative seriousness of offences will usually determine which claims takes precedence. That's a factor that the judge, Ms Justice Linden, relied on specifically.
Is this a document that fed into the guidance that we looked at earlier?
That's correct. They're materially identical. Ms Ailes took you to the guidance, which for your note is Supplementary Bundle, tab 6, page 156.
Yeah.
But just for convenience in terms of my submissions, I've used this copy.
Right.
So this is the policy which was actually annexed to the ministerial submission, which was the document that was before the Secretary of State.
Yes. So we see there 2, location of the offences. The significance may be less apparent, and the factors to be weighed may include the nationality of the person concerned. Just pausing there, my own friend Ms Ailes has dealt with that and the relevance of that under location of offences, and whereabouts of any witnesses and the location of any witnesses, and those are 2 factors that I'll concentrate my submissions on. The third is the respective dates of receiving the EAW and the Category 2 request, which claim was made first and how far it has progressed, are factors which can be considered. It may be right to make some allowance for the more onerous requirements which Category 2 territories have to meet. Pausing there, that latter point is not relevant in this case because the US request in fact came 2 years almost before the Portuguese warrant, and that is a significant factor which I'll come on to. So concentrating, if I can, on the seriousness point, we then see how this matter has been interpreted by those advising the Minister. So if we can go to Annex B, consideration of the issues, which is in Supplemental Bundle 1B, page 8. Should just be a few pages before the one we were just looking at. And we can see there at paragraph 1 how it's described that the offending, how the offending is described. It says he's accused of, in the United States, of conspiracy to commit access device fraud, 4 substantive counts of access device fraud, each of which is punishable to imprisonment of up to 10 years, and 1 count of aggravated identity theft with a managed term of 2 years consecutively. There's then a essential summary of what Mr. Santos-Cello is said to have done.
Yeah.
And in essence, it's that he controlled and was the chief administrator of a website called Raid Forums, where users traded login details, credit cards, bank accounts, social security numbers, and other personal identifying information, including details belonging to US citizens and US companies for fraudulent purposes. And then there's some more detail.
And some idea of the size and scale of the enterprise is given at the end of paragraph 4.
Precisely, my lady. We can see there's 10 billion unique records of individuals living in the UK, US rather, and elsewhere traffic through that website. And then we can see how Portugal are said to have described the offending at paragraph 8, the end of that page. It says, meanwhile, Portugal has requested Mr. Santos-Cello for the same crime over the same period of time. There he is charged with money laundering, tax fraud and illegal access. And then the figures are given in terms of the maximum sentences. All of the victims referenced over the page, all of the victims referenced in the request, either a person or a business, are based in the US. Then we have the amounts that are provided. Then we can see at paragraph 10, there are key points for consideration of the Minister's decision. It says that there are 4 matters which the Minister must consider, and dealing only for now with the first point, relative seriousness of the offence concerned. It says both offences concern identical offending. However, as recorded in the Portuguese request, all the victims are based in the US. But both requests note that there are purported victims based outside the US. neither request provides further detail or specific figures. It's unknown if any victims were based in Portugal. The period of alleged offending is also the same. And then the respective monies involved are set out. And finally, on that bullet point, as such, with the information available and given the identical facts, we are unable to fairly determine which request is relatively more serious, and we must consider whether the other matters which are determinative. And then finally, we can deal with the culmination of all of this, the submission to the Minister, which is at the same bundle, tab 3, page 4. A few pages before that. And it's paragraph 5. It should be tab 3. Apologies. In fact, it's tab 1A. It's page 4. And we can see paragraph 5, halfway down the page. Our full consideration is at Annex B, which we've looked at. We assess the points as the key points. First bullet point, both offences concern identical allegations, and it's impossible to adjudicate which request should take precedence on the known facts in each request. It's accepted that Mr Justice London, it was accepted rather before Mr Justice London, that by the Secretary of State the offending was not identical. That is incorrect based on the submission to Minister. But can I ask my lady and my lords to take you to go to paragraph 146 of Mr Justice London's judgment?
So before we get there, are you saying that you're resigning from the acceptance that it was not identical, or you maintain it but say it's immaterial?
Maintain it. Yes, thank you. So if we go to Mr Justice London's judgment and how it was dealt with by him, it's in the core bundle, tab 5, page 83. It's paragraphs 146 to 147, which I'd ask the court to read.
Yes.
I'm grateful, my lady. In my submission, the judge was correct to find the requested person had been charged with different and additional offences in Portugal. The US and Portuguese authorities have legally categorised the offences slightly differently. The additional offences in Portugal, as my lady's already pointed out this morning, are the money laundering offences and the tax offences. However, these additional offences relate to the proceeds from the alleged conduct on the Raid Forum's website.
Yes.
And therefore, in my submission they are a corollary of the core conduct. The core conduct being Mr Santos Chalo's controlling and administering these websites, resulting in the fraud. It is evident from both the US request and the Portuguese warrant that the offending is almost the same. Indeed, the introductory paragraphs to each the US request and the Portuguese warrant use almost identical cut and paste wording. And I can take my lady and my lords to that just to make good that point. So if we look at firstly the US warrant, or request rather, it's in the supplementary bundle tab 2, page 24 to 25.
Which bit of it you want us to read? The summary of the facts?
Is precisely, my lady. Paragraph 4, summary of the facts of the case in or around 2016.
Yeah.
Just ask my lord, my lady, to read just paragraphs 4 and 5, please. And then if we compare that then to the Portuguese warrant, which is at tab 3, page 92, you can hopefully fairly easily see that the wording is almost identical from looking at the top of box E, offences involved from around 2016 up until the penultimate paragraph before as part of Operations Raid Forums, which finishes through PayPal, an online system based in the United States. So in both of which there is references to the date, the fact that the credentials were used to access online accounts issued by US entities, the fact that the stolen access devices and means of identification belong to US companies and individuals, and that, as I've mentioned before, there are over 10 billion unique records of individuals residing in the US and abroad. The words used abroad in the Portuguese warrant and internationally in the US request, and that there was an online payment system through PayPal, which again is used. The reason I took these that rather long paragraph is to show essentially that the core conduct is essentially the same. The description of the claimant's role is also the same. If I just may give you the references for that, it's the US warrant, paragraph 9, and it's the supplementary bundle, tab 2, page 26. And for the Portuguese warrant, tab 3, page 92. And the specific actions of the claimant also appear to be the same as well. And there are numerous references to this. So tab 2, page 29 for the US, tab 3, page 92 for Portugal. Tab 2 for the US, page 71, and for Portugal, tab 393, and many others. And so therefore, in my submission with respect, the judge was wrong to reject the Secretary of State's submission, that the difference between the warrant and the request was one of form rather than substance. There is clearly a substantial degree of overlap between the conduct in the US request and the conduct in the Portuguese warrant, given that there is so much identical conduct that is alleged. If we take the two additional offences each individually, firstly looking at the money laundering offence, we can see that the proceeds of the core criminal conduct is set out in both the Portuguese warrant and the US request. It's very clearly set out in the Portuguese warrant, and that's at tab 393. I think we're just over the page. It's just over the page from what we were just looking at. And we can see on the final dash type of bullet point in the middle of the page, which starts before March 14th, 2018, you can see that Mr. Coelho received income into the account in the name in his name at Banco Santander and located in Portugal. These earnings were derived from the administration of raid forums, as well as the sale and or intermediation of pirated data to various databases on the platform. The amounts received were paid in virtual currency and through PayPal. We can then see also in the US request reference to proceeds of crime. And one might imagine that would be the case given the criminal conduct alleged. So if we
It's
can
not
please
suggested that the proceeds of crime went to the US, is it?
Yes, my lady,
It is.
that appears to be the case, yes. If we look at, and that must be the case because of what I'll show you now, which is the forfeiture notice, which is appended to the request, the US request. So if I could ask my lady, my lords, to go to tab 2, page 78.
Well, before we do that, can we just deal with the tax allegations against him in Portugal?
Yes. So we can see at the bottom of that same page a type of a sort of note. It says
It's noted that he's never been fiscally registered for engaging in any business activities and has not submitted any income tax declarations. Well, isn't that a self-standing allegation against him, irrespective of the fact that he's also an alleged fraudster?
I accept that that is conduct that's specific to Portugal,
Yeah.
and because it is clearly to do with him being registered or not in the Portuguese authorities. I have to
Yes.
accept that. My submission, the thrust of my submissions, is that it's still based on the same core conduct as in the US request.
How can it be?
Well, it's a corollary of that offending. The fact that he hasn't registered for income tax, it's not completely separate.
Well, it's not alleged that he's not registered for income tax so that he can declare his ill-gotten gains to the Portuguese tax authorities. It's alleged that he's never been engaged in any business, lawful or otherwise, that gives rise to a fiscal obligation to Portugal.
Yes, I accept that. But
So I can't at the moment see how the fact that he's also wanted for money laundering and fraud has any bearing on the fact that there's also an extradition request by Portugal in relation to the tax offences.
my lady, can I take you to how I think Portugal sees it themselves under their law?
Yes.
It's in the new evidence that's been provided since Mr Justice London's judgment from the Portuguese, the second trusted party. So if I may ask you to turn please to tab 6L, and it's page 378 of the same bundle. Just to be clear what this document appears to be, we can see from page 375 that this is a reply to a CPS request for further information. The request was made on the 22nd of October 2025, which was after the hearing before Mr Justice London and judgment, and this is a response that's undated. I'll take no issue with that. I can ask my lords and my lady to read paragraph 3 on page 378, room number 1 and 2, please.
That's the... Quite sure what that's saying. It's saying he couldn't be prosecuted separately for the tax evasion.
I read it, my lady, as that essentially the tax evasion offence is contingent on the other offending.
Yeah.
And the reason why that's important, my lady, is because if it is a contingent on the offending, then the core conduct, as I've said, remains the same.
Yeah.
My lady, may I just take you, just to complete the point on the forfeiture notice, just to take you to the forfeiture notice. It's in the supplementary one on tab 2, page 78. and we can see there that there's a forfeiture notice described, and perhaps the most important part of that is paragraph 47, and right at the end, I, a money judgment in the amount of not less than $571,000 representing the proceeds the defendant obtained as a result of the violations described in this indictment. So the point being that both the Portuguese and the US have described there being proceeds of crime. It's just that the Americans haven't charged it with such.
Yeah, they're slightly different processes, presumably.
Yes. And that, my lady, is also another point, that the point of extradition proceedings is not to try and compare and contrast different ways that different foreign jurisdictions deal with different offences and decides to legislate for them. And that point comes up in essence in the case of Norris, which is the only case I wish to take you to, if I may now.
Yeah.
It's in the Authorities Bundle Part 2, tab 15, and it's page 130. In this case, it was a slightly different point. The point was about whether the offence, or the conduct rather, as described in a US warrant, was an extradition offence. That is, would have been an offence if it occurred in England and Wales, an offence under our law.
Yeah.
And the point that's taken there, it's paragraphs. I invite you to read paragraphs 89 to the end of 91. So we see there that the House of Lords confirmed that when considering whether an offence is an extradition offence, the court should look at the conduct alleged as described within the extradition request and not be confined simply to that which is alleged in the indictment. So in carrying out that exercise, the court should ignore what they called mere narrative background rather than seeking to match the ingredients of the foreign offence with those known as an offence known to English law. And the point in my submission is analogous to what the court is trying to achieve in this case, or rather the Secretary of State is trying to achieve in this case, which is to look at the core conduct of what is alleged, to then be able to assess the relative seriousness of both offending. So in my submission, the principles equally apply in answers involving priority decisions. And the relative seriousness of the offenders is established by considering what the arrest requested person is alleged to have done, not what offences he has been charged with, to reflect that conduct. And in my submission, the judge was wrong to say that the mistake in the submission to Minister, that the offending was identical, was not material given the scope and effect of that mistake and the similarity of the offending. If I may then turn to the second submission, which is in relation to the place where each offence was committed. Two submissions in this regard. The first is that although it is correct that the submission to Minister and accompanying documents suggest that the victims are exclusively within the US, it does appear that in fact they were predominantly located in the US and that the harm was most significantly felt there. And in those circumstances, Ms Justice London ought to have recognised this when assessing the materiality of that mistake. And then secondly, that Ms Justice London impermissibly permitted the location of the victims greater significance than the location of the witnesses. We've already looked at to deal with the first point, we've already looked at the policy first about the location of witnesses and that they include the nationality of the person, the whereabouts of witnesses and location of any victims. And we can see then from the consideration of the issues, if I can take my lady and my lords to it, it's supplementary bundle tab 1B, page 9, paragraph 8. We've looked at this before, it's just in fact just at the bottom of page 8 and page 9. Essentially, the submission says that all of the victims are referenced in the request, either a person or a business, are based in the US. And then we can see the second bullet point the second bullet point on page 9. There is some detail there about the place where each offence was committed or allegedly committed. I'll ask my lady and my lords to read that, please. And then where that submission ended up in the submission to Minister. We have at paragraph 5, Santos Cello is a Portuguese national who is residing in his home country at the time of his alleged offending. The stated victims and witnesses in each request, however, are based in the US. On its face, a trial in the US would thus be more appropriate. In the interest of time, I won't ask you to turn to Mr Justice London's judgment on this, but essentially what he says at paragraph 153, which for your note is tab 5, core bundle, tab 5, page 85, is that the Portuguese state was overlooked as a victim. It is accepted that there is no reference in any of the lead-up documents or the final iteration, the submission to Minister, of a recognition that the Portuguese state is a victim. I accept that. However, in my submission, the court should not have rejected the argument on materiality, which Mr Justice London did at paragraphs 154 to 156, since the stated victims in both the request and the warrant are predominantly based in the US. Neither request or the warrant provide specific figures for specific alleged victims, and it's not known, and it's still not known, despite there being many pieces of further information post-decision, post Mr Justice London's judgment from Portugal, whether there were in fact individual people who were the victims of the alleged crime. But however, we do know very specifically that there are numerous victims, both companies and individuals, based in the US. And if I may just give you the tab references for this within the US request and the Portuguese warrant. It's easy to do with the Portuguese warrant, so I may just take you to that. But in terms of the US request, we can see that it says that often the stolen access devices and means of identification belong to US companies and individuals. And that's Supplementary Bundle tab 2, page 25, paragraph 4. And we can see in the Portuguese warrant, this is Supplementary Bundle tab 3, page 92. Because it's more succinctly set out in just a page and a half as opposed to tens of pages for the US warrants. There are many references to the US and no references, aside from the Portuguese state, to Portugal in terms of the victims. So if we look at the first paragraph of box E, which starts from 2016, we can see the final sentence of that, which starts, "These credentials were used to access online accounts issued by US entities, as well as means of identification, including name, email addresses, and social security numbers." Then the following paragraph at the end, "Often these stolen access devices and means of identification belong to US companies and individuals." Then we can see the two paragraphs along, starting raid forums. Raid forums engage in the trafficking of pirated data, of offering hundreds of databases for sale, comprising over 10 billion unique records of individuals residing in the US and abroad. And then we can see further down, finally, until January 2022, members could be also acquire credits through PayPal, an online payment system based in the US. So the only reference to there being anybody a victim to these core offences outside of the US is a reference to and abroad. In my submission, that is not significant enough to suggest that the dial moves significantly away from the US. Yes, of course, abroad could include Portugal, as it could include, of course, everywhere else. And it's simply not specific enough to draw such a conclusion in my submission. Secondly, looking at the importance of victims over witnesses and the, in my submission, impermissible substitution of Mr. Justice Linden's views for those of the Secretary of State in determining that the location of the victims was more important than the location of witnesses. At paragraph 155 of Mr. Justice Linden's judgment, it's tab 5, page 86, the core bundle, he says that the location of the victims and the claimants offending was more relevant to that consideration than the location of the witnesses. However, looking at the competing requests guidance, which we've already done today, paragraph 2, Roman numeral 2, so it's a bundle, tab 1C, page 11. Under the location of offences, it simply says the whereabouts of any witnesses and the location of any victims. And even reading it on a straight view, it actually puts the witnesses before the victims. In any case, there's no hierarchy which is suggested and in that guidance. And the respondent hasn't challenged the lawfulness of that current policy. So my submission is no sound basis for placing one above the other. They both, in reality, go to the practicality of a trial, whether a trial occurs in either jurisdiction, Portugal or the US.
Well, it's more than that. If you've got a whole host of victims in the home country, and the home country is requiring somebody's extradition, those victims will also likely be witnesses, or they might be witnesses, whereas the witnesses that are coming from the rival country might well be enforcement agents or investigating officers who really don't have any nexus in the real sense with the criminal offending. So it's a question of fact and degree on the individual case, isn't it? And one of the factors that Mr. Justice Linden is saying plays some part, or should have played some part in the overall evaluation, is the fact that the state says it's being robbed of its taxes.
Yes, my lady, I entirely accept. Of course, it has to be a fact-specific exercise. And in my submission, in this particular case, had that been done, it would have been seen that the majority of the identified victims
Yes.
are in the US.
Yes.
And therefore, those individuals are much more likely to want to have a trial than those in their own country, in the US, and individually come over in their tens, in their scores.
That's why I
to
wasn't
Portugal.
quite sure why you were spending so much time on hierarchy between victims and witnesses, because most of them seem to be in the US, whatever you categorise them as.
Precise, my lady, and that was the first point.
Yeah.
My lady, yes. The second point is my lady's already identified, which is in relation to the law enforcement officers. I accept, of course, that evidence coming from professionals is likely to be easier to transfer, although we do know that in this case that covert human intelligence sources were used, and I'm afraid we don't have any specific evidence on the availability of that to be transferred over jurisdictions. However, I would suggest, if I may, that judicial notice could be taken that may be an impediment in any case, or it may be more difficult than if they were just ordinary victims, ordinary witnesses rather.
Yeah.
And then finally, there is the other error, the third issue. It's submitted that all of these issues need to be considered alongside the judge's wider approach to the facts, and in particular, consideration of section 1793C, which is the respective dates on which the claim was made and how far it is progressed. It doesn't appear that the judge, Justice Linden, has considered this factor, and given the fact that that is overwhelmingly in favour of the US, and that is set out both at the consideration of the issues.
Well, how does that
Annex B.
help? Because that's a matter for the Secretary of State, surely. The question is whether or not certain material factors were left out of account in the decision. The judge himself doesn't have to consider all the material factors. What he has to do is to decide whether or not what was left out is of significance. So at the moment, I don't understand this point.
I accept that entirely, that it is, I should say, no criticism of Mr. Linden for not addressing that specifically, in that sense. But there is a problem in my submission when you have to look at all these things in a round. If you're looking at how the factors were taken into account, some should go up, some should go down, some turn the dial. Yeah. And it's then, and in this case, Mr. Linden found precisely the opposite, of course, to the factors that have been identified and assessed by the Secretary of State to have been in terms of whether they are for the US or for Portugal. That means that essentially a whole reassessment will have to take place to look at how the dial is moved in which direction.
Well, it will be open to the Secretary of State, surely, because the Secretary of State's not bound by what Mr. Justice Linden thinks is important with respect to him. The Secretary of State could retake the decision and say, actually, having thought about it again, now that I've been corrected on the facts, I've come to the conclusion that everything points to the US, and I'm going to make the same decision, but now taking into account everything that's material. There's no problem with that.
No, my lady. That's certainly a possibility. Finally, and for completeness, it's also submitted that the conclusion of the Secretary of State's decision was irrational not to include consideration of the respondent's nationality, mental health and risk of suicide, and this follows from the submissions my own friend Miss Ailes made.
If she's right about that, then it couldn't be irrational not to take it into account.
Precisely, my lady. My lords and excellencies, do any further? Those are my submissions.
No, thank you. Thank you both very much indeed for your clear and succinct submissions. I think there's no point in using 2 minutes in order to embark upon the respondent submission, so we'll meet again at 2 o'clock.
Court rise at table.